Good evening, ladies and gentlemen. My name is Leo Stoller. I'm the Executive Director of Americans for the Enforcement of Attorney Ethics, AEAE. AEAE is a well-known attorney disciplinary watchdog and governmental ethics watchdog group located here in Chicago, Illinois. My name is Leo Stoller, and in many litigation circles, I am well-known litigator in this country. The reason why I am talking to you this evening, and the subject I want to discuss with you, is the subject of a vexatious litigant or a vexatious litigator. Now in California, there's actually even a law against vexatious litigants. And what is a vexatious litigant? According to California law, a vexatious litigant is a party who brings a lawsuit that's frivolous in the court system, and it's declared frivolous. AEAE does not believe that there is any such thing as a vexatious litigant. The reason why we say that is that anybody in this country who files a lawsuit in a court of law, whether it's civil court, an administrative judge, or a district court, a federal court judge, under the federal rules of civil procedure or the state rules of civil procedure, is not a vexatious litigant. A vexatious litigant, in the opinion of AEAE, is a terrorist, someone who acts outside of the law, such as those that we see every day in Iraq or in the Gaza Strip, where the Palestinians and the Arab terrorists are blowing themselves up, not acting within the law, not suing in courts, but taking the law into their own hands, are anarchists. The reason why I suggest, or AEAE believes, there is no such thing as a vexatious litigant, is that anybody in America who is wronged or feels they have been wronged and want to redress those wrongs, we have a court system that the framers of our Constitution set down the groundwork many, many, many years ago and set up a Constitution and amendments to the Constitution. The Fifth Amendment and the 14th Amendments in particular state that a party should not be deprived of his due process or equal protection under the law. He must receive notice, must have an opportunity to present himself in a courtroom, and act under the rules of civil procedure. Therefore, if a party is found to have a case which may be frivolous, a judge has the right to sanction that person in the court system. However, many courts within this country, in America, have come to conclude that parties that continue to bring individual pro se parties, parties acting on behalf of themselves, bring cases over and over again within the court system, are declared by many as a vexatious litigant. This is incorrect. There's no such thing as a vexatious litigant or even a vexatious litigator in this country. As long as they are following the laws of this country, filing a lawsuit in a court of law, and abiding by the appropriate civil rules of procedure for the state or federal court or wherever they're filing their lawsuit. If the case is frivolous, then the judge will sanction that. But to sanction a party merely because he has a grievance and files a lawsuit in a court of law or files a series of lawsuits or continues to sue within the system should not be found as a vexatious litigant under any circumstances.